Yes, Mr.
May we move on to Ulster and Lamb, please, which you'll have to find in Authorities Bundle 1 at tab 5.
Yeah.
Which is internal page 79. My lords, if you could cast your eyes over the head note.
Yeah.
You can see that.
So I'm so sorry, I'm in disgrace. Can you just give me the reference again?
Oh, I'm sorry.
No,
yes, it's Authorities Bundle 1, tab 5.
AV1, tab 5.
AV1, tab 5.
Yep.
So, my lords, you can see that, that there was indebtedness to the bank, there was a guarantee of the whole debt, there was part payment by the sureties, not of the whole debt. The bank sued the debtor for the whole amount, and it was held that the payments by the sureties, since they did not discharge the whole debt guaranteed, did not discharge pro tante the liability of the defendant. And if I can just take you to a couple of passages from judgments. If we could move forward to internal page 164, that's 8 pages to, and it is lines 23 and following, where Mr. Justice Lowry stated the facts and continue, then the principles governing this type of case are discussed in Ellis Rees, which we've seen, Holder, and are well illustrated by the judgment of William Williams as he then was in Rees. And then moving forward to line, he then moves on to, the question whether the guarantee is of the whole debt or part of the debt. And of course, the reason why that matters, as your lordship knows, is that the right of subrogation does not arise until the sureties discharge their entire liability to the creditor. And then if we can go forward to 166, line 23.
Line
23.
Thank you. Sorry.
And if you'd be kind enough to read through to, in this section, actually, let me tell you what I'm doing first. In this section, the judge considered the contrary argument based on McKinnon's trustee. That's what he's doing in this section. And if I could start with 168, if we go forward just to 168, line 21, because you'll see that at line 21 there's the end of a quote. I'm going to go back to the quote. But he says, I respectfully adopt this statement of principle, and even if the observations in McKinnon's case point away from the following in Rees, I prefer the reasoning in Harvey's case, which is a salutary reminder of the importance of the terms of the contract in a particular case. And the reasoning is in the passage that starts at 167 at line 34 through to 168 at line 21. And that I would ask your lordships to please cast your eyes over. And if I can just tell you, the question is whether the surety has the right to interfere, the creditor's right to rank for the full amount of the debt. And if the surety hasn't fulfilled the whole of his obligation, he is not entitled to come into competition with the creditor, which is why I said to your lordships earlier that the competition they're concerned about is between the surety and the creditor coming into competition and going for the debtor.
The quotation is from Harvey, is that right? Not McKinnon?
That is absolutely right, my lord. So you can see there are references to McKinnon further up the page on 167, but then that's dealt with, the point is dealt with through the quote from Harvey's case, and that is the point that Mr. Justice Lowry agrees with.
The theme that's run through all these cases that you've showed us on this point so far is it's all a question of construction of the guarantee. And I'm conscious of the fact that we haven't actually seen the guarantee. I'm not even sure it's in the bundle.
Well, for the purposes of this, no, but I will show you the settlement agreement, and that is what's happened to the contract between the creditor and the surety. But I'm going to come back to that, my lord. I will come back to that on the facts of this case. Can I just pick up on page 169 at line 16, which is Mr. Justice Lowry's conclusion, and your lordships will see that what he says is the true principle is that where the entire debt is guaranteed, with or without a limit, the creditor can sue the principal debtor or claim in his bankruptcy for the full amount of debt despite any payments on foot of the guarantee, whether they are made before or after the principal debtor's bankruptcy, provided those payments in the aggregate fall short of the full amount of the debt. The benefit to the guarantor is that money recovered in excess of the full amount of the debt is held in trust for him. The rights of the other creditors of the principal debtor are not infringed, since the bank is at all times entitled to rank equally with other unsecured creditors in the principal debtor's bankruptcy, and has independently of this right contracted to receive from the guarantor payment to supplement the dividend on the entire debt. If the entire debt is discharged, the creditor has no further interest, and the guarantor stands in his shoes. And my lord, that is a very neat summary of what the position is in relation to guarantees. Sorry? If the principal debtor remains solvent, the question of justice among his creditors does not arise. So, provided the payments in aggregate fall short of the full amount, because it's not until the surety has discharged his liability to that creditor, the right of subrogation then arises. And can I then, in the clip, there should be an extract from Chitty, which I think is notionally down as Authorities Bundle 5 at tab 92. But I think you might have it in the clip that was sent to you this morning.
Yes.
Yes. Excellent. So this is, there are two extracts from Chitty. The second extract, I think, my lord, is the extract your lordship referred to yesterday. But I want to show your lordship the extract at 45078, which is on page 2952. And this is, my lords, what Chitty says, where a guarantee, whether continuing or for a particular transaction, is given subject to a limit on the amount for which the surety may be held liable, one important question of construction often causes difficulty. This is whether the surety has guaranteed the whole liability or debt, though his own liability is for the limited amount, or whether he has guaranteed only part of the liability of the debt, and that's because that determines whether his right of subrogation arises. The distinction is important principally where the debtor or the surety becomes bankrupt. If the surety has guaranteed only part of the debt, he pays the creditor the amount for which he is liable, then in the event of the debtor's bankruptcy, the creditor can only prove against the bankrupt trustee for the balance of the debt, while the surety can prove against the bankrupt trustee for the amount he has paid. Similarly, where it is the surety himself who becomes bankrupt, the creditor can only prove against his trustee for the part of the debt which he has guaranteed. On the other hand, where the surety has guaranteed the whole debt, though subject to a limit on his liability, the position is different. In the event the creditor can prove for the whole debt against the bankrupt debtor, even though the surety has paid under his guarantee, and the surety has no right of proof of his own, at least until the creditor has recovered 100 pence in the pound. Similarly, if the surety is bankrupt and has guaranteed the whole debt, the creditor can prove against his trustee for the whole amount, but he cannot, of course, recover more than 100 pence in the pound. Even when no bankruptcy is involved, the distinction may sometimes be important, for it seems that the creditor can recover judgment against the debtor for the whole debt, even though the surety is paid under his guarantee, unless the guarantee is part of the debt alone. If the creditor recovers more than the balance remaining unpaid, he must account for the surplus to the surety. And if you look at that note, 410,
Yeah,
Ulster Land. May I then move to, in the same Authorities Bundle 1, to tab 15, please. This is Westpac Banking Corporation in Colin.
So just pause. You've also given us 45084 in this clip. Would you say that's wrong?
Yeah.
That was the passage I had in mind.
Yes, that's the passage you had in mind. And the point... Sorry? Yeah, I mean, we're going to show you, Lordship, why Milverton doesn't apply. And you've got...
that may be right, but what the Chitty says is where a surety enters a contract at the request of the principal debtor, it's clear the payment of the debt discharges the debt as between principal, creditor and principal. Surety cannot sue the principal debtor for an amount of debt which the creditor has already received. That you say is not right.
No, it's not right. This is right. That isn't right. They're both in the same book. Now, whether this is a case of Homer nodding or not, I can't help. But what I can do is show your Lordship the authorities and show your Lordship the extract and Chitty which you've got. And so Westpac.
Westpac. Yes. Where was that?
Westpac is in Authorities Bundle 1, tab 15 at 259.
This is Mr. Justice Tadgell.
This is Tadgell, so I'm not going to labour the case, but I just want to... It's a decision of the Supreme Court of Victoria, Mr. Justice Tadgell, and if I may, just have a quick look at paragraph 1. A single short question is, it is whether the debt claim should be admitted to proof to the extent to which it remained unpaid out of the funds of the debtor company at the commencement of the winding up, or whether there should be a reduction in the extent of payments made to the creditor by a guarantor of the debt before the commencement of the winding up. And then if we can go on to 263 at the top, 4 lines down, you'll note that is where they are.
Well, I think you need to look at 261, just by the second hole punch, where he says the cardinal submission for the liquidator was that if before he proves a creditor is paid part of his indebtedness, either by the debtor or by a guarantor, then the payment extinguishes the debt pro tanto. So that's the argument he's dealing with.
Yes. And your Lordship will see that the answer is no. And the essential reason for this is, and so back to the top of 263, the reason for this is when the principal debtor is bankrupt, the surety is paid in full of guarantee comes potentially into competition. Again, it's a reference to that competition, which I just wanted you to see. But then at 263 at the bottom, having dealt with the authorities, these authorities form part of a considerable body of support for the conclusion that a creditor who proves in the bankruptcy of the debtor need not deduct from the amount of his proof any sum paid to him by a guarantor on foot of a whole money's guarantee, so long as any part of the guaranteed debt remains unpaid by the bankrupt estate. The conclusion was precisely expressed by Mr. Justice Vaughan Williams, and then there is a reference to Justice Lawrence and Fenton, when he said, and perhaps you cast your eyes over the page, Lord Justice Fenton's quote. And your lordships will pick up that he refers to SAS.
Yeah.
And then, my lords, along similar lines, at the top of 268, at the top, this was essentially the view adopted by Miss Justice Vaughan Williams in SAS. And picking it up at the bottom of 268 is the passage that's picked up in Ulster and Lamb, where he talks about the principles, and he says, I respectfully, at the bottom of 268, so that's the passage in Ulster and Lamb, and then over to 270, where just the two-line, the bottom paragraph, the single exception among the authorities, so far as I'm aware, that has applied the reasoning of the cases dealing with negotiable instruments in the case of whole money's guarantee is McKinnon, the cautioner, with a view to terminating his liability as such, paid off his liability under the guarantee before the commencement of the bankruptcy of the principal debtor. The creditor sought to prove in the bankruptcy the whole of its debt without deducting what had been received from the cautioner. The course of session held that the deduction should be made from the proof. There were other facts not now relevant that in any event went to defeat the creditor's attempt to resist the reduction of proof. The court went on, however, to say that the payment by the cautioner, having been made before the sequestration of the debtor's estate, extinguished the debt pro tanto, thereby necessarily reducing the amount for which the creditor could prove. The court treated the matter as covered by the earlier authority of Hamilton and Cuthbertson. The fact that that case involved a claim in bankruptcy upon a bill of exchange was held in McKinnon's not to be a relevant distinguishing feature, and there is then a quote from Lord Salverson, and then picking up the last 6 lines, to take that approach in the case of a whole money's guarantee is to leave out of account the terms of the guarantor's obligation, in other words, to guarantee all of the sum due, and the creditor's corresponding right not to suffer competition from the guarantor. It is not, in my view, in accord with the authorities to which I have referred. Justice Lowry in Ulsterbank took the same view of McKinnon's case and declined to follow it. I respectfully adopt his criticism and take the same course. And just at the bottom, you can see just before the break, if therefore the guaranteed creditors entitled between themselves to proof for the whole, and so on. Now, this body of case law represents the orthodox position, and it draws support from all the leading textbooks on the law of guarantee, including Legal Problems of Credit and Security, which was formerly edited by Sir Roy Good, now edited by Professor Gulliver, The Modern Contract of Guarantee, which is O'Donovan and Phillips, and The Law of Guarantees, which is Andrews and Millett. I'm going to show you, if I may. Could we take up Authorities Bundle 4, tab 72, and I wanted to look at internal 414, 6 lines down. If the Lord,
This is good and got it.
Yeah.
Yes.
and I just wanted to pick it up 6 lines down, where it starts, although every case ultimately depends on the construction of the agreement. The general rule outside insolvency.
No, I'm sorry, I don't have you. I'm on page 414.
Which is in the bundle 2382.
2382, yes, and
Yes.
then you were reading from.
6 lines down.
Thank you, I'm sorry.
No, it's my fault, my lady.
Yeah, got it.
Although every case ultimately depends on the construction of the agreement, the general rule outside insolvency appears to be that the part payment by the surety does not prevent the the creditor suing a solvent principal debtor for the whole amount of the debt. And as your lordships have seen, and my Lord Justice Lewison just put it to me, it depends upon whether the contract of guarantee entitles the surety to compete with the creditor.
It's also worth perhaps noting what the learned authors say on page 412 at the top, saying really what a difficult and obscure subject this is. For some reason, conflicting authorities and obscure reasoning seem endemic in the earlier bankruptcy cases, etc. I'm suggesting this is really a notoriously difficult minefield, rather than the absolutely clear propositions which you're suggesting rule the position.
Well, I hope that I will shine enough light on it that your lordship will agree that this is indeed clear.
Fine.
Sorry? And I don't say that lightly at all. And then it carries on. If the creditor recovers in full from the principal debtor, he is obliged to reimburse the surety. Support for this view comes from Ulster and Lamb, where the debtor was solvent, as well as from dicta from the insolvency case of Re-Sass. So I'm going to leave that there for now. The surety is not entitled to compete until it has discharged its liability to the creditor and the right of subrogation arises. That is the proposition that one gets from all of this. And then tab 75, this is the modern contract of guarantee. And I just wanted to go to 2422. And I wanted where it's 1051. Lowry specifically disapproved McKinnon's trustee, Bank of Scotland, submitted that this view should be preferred. The decision in Ulster Bank appears to be correct because in accordance with the principles outlined in the previous section, if the guarantee is of the whole of the principal's indebtedness, the creditor is entitled at all times to treat the entire debt as owing. And it's worth noting that is the fundamental principle. And there remains an outstanding obligation on the guarantor to see that the whole debt is paid. It should be irrelevant whether the guarantor makes payment before or after the bankruptcy. Now, I just now want to turn to cases relied by my learned friend. And the first, that is Milverton and MS Fashions. I'll deal with them chronologically. The first is Milverton. But before I turn them up, 3 preliminary points. Milverton has only been cited in England once in the 26 years since it was decided. And for your note, that was a case called Romain and Scuba, which is not in the authorities bundle because it is not on point.
About limitation.
My lord, you are ahead of me. The so-called general principle it supports is not referred to in any of the leading textbooks. And like the commentators and academics, we agree that this is a case specific to leases, where the obligation of the guarantor is the same as that of the tenant, and it is of no general application.
I must say I don't understand that. I don't see why a guarantor's obligation in a lease should be different from any other guarantors.
It's because it's a principal liability. The way in which it's dealt with, well, we'll see in Milverton.
There's always, or nearly always, going to be a direct covenant between the guarantor and the creditor. So why does that not turn it into a primary liability?
Well, with respect, no, there isn't. No, you've got to separate the principal liability, which is in the contract between the debtor and the creditor, and the secondary liability between the creditor and the guarantor. The guarantor might have a direct liability, but that is a separate question, and then you're enforcing the primary liability between the guarantor and the debtor.
Guarantor and the creditor.
And the creditor.
Oh, I see.
Yeah.
Sorry, were you suggesting?
So yes, I'm sorry. Perhaps I'm missing something, but I mean, surely there's always going to be a contract between the creditor and the guarantor, from whom the creditor has
No, I'm
the
sorry,
guarantee.
I misunderstood your lordship's
So
question.
why is that?
You have to.
Yeah. So why does that not give rise to a primary liability as between the two of them?
No, you have to look at the liability and see whether or not it is primary or secondary. If it's a primary liability, if you enter into an agreement, which is what you get in Milverton, where you say, and we've got the 6 individuals, you all contract with the creditor that you will all pay the rent and you will all do the other things that are contained in the guarantee. That is a primary liability. Yep. If you enter into a contract with the creditor whereby you say, if the debtor does not pay you, I will pay you, that's a contract of guarantee and a secondary as opposed to primary. And that is the difference. And actually that's the difference as one of the important differences in MS Fashions.
I understand that, but why is there some special rule for leases that I don't understand?
Oh, well, my lord, all I can say is that on the facts in Milverton, on the contracts, it was a primary liability. The authors have all then said, well, it's a problem that arises in leases because it's a primary liability. I agree with your lordship. If you've got a primary liability, you've got a primary liability. But I do not profess, I do not practice in landlord and tenant work, and I do not profess to be able to tell you, well, this is a feature of landlord and tenant, and before your lordship, that's the last thing I'm going to try and do. So, I take your lordship's point, but I'm not one of the academics. And it doesn't matter for present purposes whether it's specific to leases. Right. So may I...
yes, we're going to Milverton.
Move on to Milverton, which is in tab 19. My lord, I think the lordships have seen that head note.
Sorry, I'm behind you. If you wait a moment, I'll be grateful.
Apologies. Authorities Bundle 1, tab 19.
Thank you.
Thank you, Lord. Can we, if I can take it that your lordships have seen the head note, can I move to Lord Justice Glidewell at page 3? Lord Justice Glidewell gave the first judgment, and it starts at page 3.
Just before we go there, can we just look at the head note 3 lines down? The licence contained a surety covenant by DB that MT would pay the rent and perform the covenants.
And perform the covenants.
Well, yes, but that's a guarantee, and that's a straightforward common or garden guarantee. It's not a primary liability at all.
Yes, it is. As long as they're paying the covenant, performing the covenants, that's primary.
But he's covenanting that MT would do that, not that he would.
Surety covenant by MT that...
By DB, that MT would pay the rent and perform the covenants. That's classic C2IT guarantee.
The term further assigned pursuant to the licence.
And then there's a covenant for indemnity, which is also a secondary liability. So I can't see where you get this primary liability from.
Sorry? Well, you'll see it from Lord Justice Russell's judgment.
Glidewell. Yeah.
So you'll see it, my lord. But can I start with Lord Justice Glidewell?
Yeah.
At page 3. So he says, this appeal concerns the question whether a lessor who has received from a guarantor of the lessee's covenant to pay rent a payment in consideration of his releasing the guarantor from his obligations under the contract of guarantee is obliged to give credit for that payment in seeking to enforce against the lessee, whether the original lessee or a lessee by assignment, covenants contained in the lease to pay rent and make other payments. So that's recording the question. In relation to the facts, your lordships will probably pick this up. The instalment of rent due for Michaelmas Day 1991 was not paid. Wilcox and Beveridge entered into a deed of release with the landlord, whereby the landlord agreed that upon receipt of the 50,348 guarantors, they would be released from all their obligations. And my Lord, one of the points that your Lordship should pick up is, of course, the guarantors had ongoing obligations to pay the rent, and you'll see that. Wilcox and Beveridge paid their 50,000 odd. The tenant was sued for the outstanding rent and pleaded that the landlord had received that 50,000. If we can look further down, where it says September the 10th, 1981, the licence, which was under seal, was expressly made at the request of Mr. Donald, Mr. Bailey.
Sorry, where are you reading from?
Oh, I'm so sorry. This is the first, second, third, fourth paragraph on page 347. I'm still in 347.
Oh, I see, yes.
So September the 10th, the licence, which was under seal, was expressly been made at the request of Mr. Bailey and contained a guarantee by Mr. Bailey that the assignee marketing trends to pay the rents reserved and perform the covenants containing the lease, and provided that if the assignee should make default in payment of the rents or its observation of the covenant, the surety will pay and make good to the lessors on demand of losses, damages, costs, and so on. The clause also expressly provided, and I think, my Lord, this is the answer to the question, the covenant on the part of the surety shall be deemed to impose upon the surety the same obligations as if the lease had been granted direct to the surety as tenant. And your Lordship will see that is significant. And if I can go to 351, which is page 7 internally, to Lord Justice Hoffman's judgment. Lord Justice Hoffman, you have the bottom of 351, said, under the terms of the lease and the two licenses to assign, there were 6 persons liable to pay the rent and observe the covenants. So there were 6 obligors. And over the page, 1, 2, 3, 4. It's the 5th paragraph that starts in the middle of the page, but this is not how Lord Justice Russell put it.
Yeah.
He said that the guarantor had not paid rent. It was true, he said, that the payments were made because the tenant failed to pay the rent. But in law, they were nothing but payments under the guarantee in satisfaction of the third party's contractual obligation. This distinction between the rent payable by the tenant and the contractual obligation of the guarantor cannot, in my judgment, survive in the decision in P&A Swift Investments. Lord Templeman said, a surety for a tenant is a quasi-tenant who volunteers to be a substitute or 12th man for the tenant's team. I promise I didn't have that in mind every year. And is subject to the same rules and regulations as the player he replaces. In other words, there is a single set of obligations to pay the rent and perform the covenants owed by both tenant and guarantor. This was the view of Mr. Justice McGarry in Hawkins, with which I respectfully agree. And
you say that's right, do you?
yes, my Lord.
Right.
And my Lord, your Lordship has seen.
Well, a couple of questions arise out of that. First of all, the statement from Lord Templeman in P&A Swift is directed to guarantors, sureties, not to somebody who is a principal obligor. It just says a surety is like the same set of. So it's not anything to do with landlord and tenant law. This is the position of the surety. And the second observation is that in Hawkins, which Lord Justice Hoffman likes, Mr. Justice McGarry said a debt is a debt, whoever pays it.
That is a concept I completely understand. But I think the point in Milverton, my Lord, arises out of what this clause expressly provided. And it's that passage which I showed to your Lordship.
Yeah.
Now, whether this applies to all landlord and tenant cases matters not.
Well, it's not a question of whether it applies to all landlord and tenant cases. Does it apply to all cases where the surety covenants or agrees with the creditor as principal debtor, which
Well, then,
many surety covenants do?
Yes, well, no, if they're a principal debtor, they're a principal debtor, and that payment will discharge the debt. But it's because it's a principal debtor.
Right.
It's not the guarantor discharging, the guarantor paying the creditor that discharges the debt. It's because you've got a direct principal-debtor relationship between the surety and the debtor.
So if the surety also covenants as principal debtor, then payment by the surety does discharge the debt either wholly or pro tanto.
Yes, yes, because that's not a payment qua surety.
Yeah.
My lord, if one's looking at the triangular relationship, surety, creditor, debtor, you've got another line there, and it's pursuant to that obligation, which is a direct obligation between the surety to the debtor. Right, so the reason why this is important is that whilst payment by a primary obligor discharges the debt to the extent of the payment, payment by a surety only gives rise to an obligation upon the creditor to reimburse the surety if and to the extent that the debtor repays in full. And qua surety, payment will always be to the creditor. The defendant, the debtor will always also pay the creditor, and if the creditor receives more than 100%, he accounts to the secondary obligor, because the creditor in that situation did not need to rely on the full extent of his guarantee, and that's the nature of a secondary liability. It is only, they're only liable if the primary obligor does not satisfy the liability. If the primary obligor does, there's no liability at all.
Can we just go back for a moment to Lord Justice Glidewell? The question he posed for himself on page 5, between the two hole punches, was: does payment by a surety of an instalment of a lessee's rent discharge the lessee's obligation to pay the same rent? So that's a question posed in quite general terms.
Yes.
And he answers that on the next page, in the last line of the sidelined paragraph. If the lessor does recover from the sum from any one of the three, the rent has been paid. The other two cease to be liable, but they're still liable for further rent.
Yes, for the further rent going forward.
Yes, and Lord Justice Kennedy agrees with Lord
Yes,
Justice Glidewell.
that's because that is a primary obligor paying for the obligation.
Well, that's not the questions he asked himself, though. He asked
Well, on the
himself
facts-
whether payment by a surety discharges the rent.
It's interesting because often you see in some of the cases loose descriptions, and the payment that's being made on this contract in this case is by a primary obligor.
Right.
So do you then say the same about the passage cited from Lord Templeman, where that appears to be a general proposition? A surety of the tenant is a quasi-tenant who volunteers to be a substitute, etc. You say that really the analogy is only correct if there is
If they become a primary
if there is a primary
Yes,
covenant by the
Yes.
surety.
yes.
I mean, again, that is simply not what Lord Templeman says.
But that is
Maybe
what
in
it,
context,
that
but-
is right, Noel.
Well,
That is
you
what-
say it's right, but
No,
it's nice if all these very distinguished judges says.
no, this is, your lordship is picking on sentences without the full
Yep.
relationship context. And there are two points, the primary obligor point and the appropriation to specific payments point. And those 2 points are identified in the textbooks. And in the same vein, the Supreme Court of Singapore has said that Milverton is a case specific to the general, with a specific exception to the general rule. And I don't, whether it applies only in a leasehold context or not, matters not. It's the question of whether it's a primary obligor. But I just want to show you two of the textbooks. Can I take you to Authorities Bundle 4 at 1072? And I'm taking you back to Good and Gullifer on legal problems of credit and security. I'm going to 2382 again, and this time, because it's the same passage,
Sorry, where are we going?
I want to go to, are you on page 414, my lord?
414, yeah.
Tab 74. This is a later bit of the same passage. Good and Gulliver. My lords, if you could, it's about 15 lines down, and it's the word on the right-hand side, the other cases cited by Fisher, is Milverton.
Yes.
And then I just want to pick up, in that case, the Court of Appeal decided that payment of rent by a surety discharged the lessee's obligation to pay the same rent, but arguably this is not of more general application, as first in the landlord and tenant situation there's a single set of obligations to pay the rent and perform the covenants owed by both tenant and guarantor, and secondly it's at least arguable that the payment of the rent was payment in full of that particular obligation relating to that particular period. If it is right that even outside insolvency the creditor does not need to give credit for part payment by the surety when suing the debtor, the main plank in Ms. Justice Fisher's argument, namely that the rule should be the same outside and within insolvency, falls away. So that is the first of them. Now, whether, but your lordship gets the point, it's the primary obligation point. And then in tab 75, which is, again, the modern law contract guarantee, and it's on 242A, and it's just the footnote 193. And I just
sorry, so I'm in the right tab, but then which page am I turning to?
2424A, my lady.
Thank you.
My apologies, I'm not.
No.
Footnote 193, and I wanted to pick it up almost in the middle where it says the reasoning in Milverton.
Yes.
The reasoning in Milverton can certainly be interpreted that way, though the decision could be confined by reference to these factors. One, the defendant seeking to reduce its liability, the original lessee, was not strictly in the position of a guarantor vis-à-vis the defaulting assignee, in respect of whose liability payments have been made by others. Two, the other paying parties had a higher degree of responsibility for liability than the original lessee. Three, it might be argued that some of the payments have been appropriated to a divisible obligation, a particular instalment of rent, so as wholly to discharge that obligation, and it then refers to Gulliver, good and Gulliver. So, my lords and my lady, MS Fashions. That is in Authorities Bundle 1 at tab 16. And
I haven't understood the first of Donovan's points. The defendant wishing to seek to reduce its liability, the original lessee, was not strictly in the position of. So the landlord sues the original lessee, is that right, in Milverton Group? Warner World was the original tenant.
yeah, my lord, the reason is that the sureties, if I can put them in inverted commas, were primary obligors, and that's the point that he's making as well.
No, he's making a different point with respect.
Oh, sorry.
Donovan and Phillips are making the point that it was the original tenant,
Yeah.
who obviously was a primary obligor when the lease was granted to it as original tenant.
Yes, I see that.
That's the point he's making.
Yeah.
And that's what happened, wasn't it? I'll go back to look at it.
But then he moves on to the other paying parties.
Yes, he does.
It may be that
that's why I said I didn't understand his first point.
No, I understand, my lord. I'm sorry, that
anyway,
was not helpful.
I'll go back over it if necessary. So we're going to MS Fashions.
I want to go to MS Fashions, if I may. That is in Authorities Bundle 1 at tab 16.
15.
16.
16.
16, yes. And it starts at 273. So, my lords, can we start with the head note?
Yes, and you did say you were going to take these in chronological order, but in fact, MS Fashions precedes Warner. Milton.
That is a perfectly fair criticism, my lord.
Sorry?
Your lordship's criticism is perfectly fair.
No, it's not a criticism, but...
No.
MS Fashions is decided in 93 and Milton 94. Yeah.
Well, the one point that I can take from that is Milverton didn't cite MS Fashions. But now, if we may, let's look at MS Fashions. And looking at the head note, it's very important that we are grounded in the underlying facts. Between 84 and 89, 3 company directors each signed as a principal debtor an agreement with the bank whereby as a guarantee for repayment of loans by the bank to the company, which was MS Fashions, the bank could withdraw money from his deposit account, is the director's deposit account, the debt due from BCCI to the director. The bank is BCCI, and that's why all of this arose. With the bank towards satisfaction of the company's debts due to BCCI. So the BCCI owes the directors debts on their deposits, and the company, MS Fashion, owed BCCI money. In 1992, the bank was compulsorily wound up. The directors and the companies issued notice of motion seeking declarations that the directors were entitled, pursuant to Rule 490 of the Insolvency Rules, to set off. I'm sure your lordships are familiar with Rule 490. To set off the sums in their deposit accounts against the company's respective liabilities to the bank. And so you've got the 3 company directors. They've signed a guarantee arrangement as a principal debtor. The company could withdraw money from their deposit accounts in satisfaction of the company's debts. And it's the key point. One of the key points is that they're principal debtors, and I'll explain why. If they were principal debtors, sums due from the bank to them on those deposits would be subject of set-off and would automatically reduce the sums due from the company to BCCI. If they were sureties, that gave sureties had given charges over their deposits, there would be no set-off because it would be a principal obligation due from the bank against a contingent obligation, principal obligation due to the bank, and it would be a contingent obligation due, no, I'm sorry, I was right.
Principal obligation from the bank, their credit balance.
Against the debt. And that would not have been mutual dealing. And that was the point. The directors sought to set off the sums due from the bank in their deposit accounts against the company MS Fashion's liability to BCCI. Existing cross-claims arising out of mutual dealings result in an automatic set-off under Rule 490. And if we then pick up the head note, dismissing the appeals, where there were existing cross-claims arising out of mutual dealings before the commencement of the winding up of the company, because as your lordships know, the set-off is taken at the commencement of the winding up. Rule 490 of the Insolvency Rules took effect so as to bring about a set-off. But where a liability had been entered into by the principal debtor, it was a primary liability, not contingent on the making of a demand in writing, which is why I said to your lordships it would have been a contingent liability and could constitute a valid cross-claim for the purposes of the rule. And that accordingly, the indebtedness of the companies, that was MS Fashions, as at the date of the winding up of the bank, had been extinguished or reduced by the amounts which on that date were standing to the credit of the directors on their deposit accounts. Yeah. And Mr. Justice Hoffman, may have been Lord Justice Hoffman at that point. At first instance, said, therefore there was a set-off, and the Court of Appeal agreed. And if I can go to 430,
I think he heard the motion as Mr. Justice, and by the time he gave judgment, he'd become Lord Justice.
well, they were lucky that he hadn't become Lord Hoffman. But yes, if I could just pick up in Lord Justice Hoffman's judgment, 430, letter C, on the insolvency of the bank, can the director set off his claim for return of his deposit against his liability to pay the company's debt, so that the debt is wholly or pro tanto extinguished? And of course, the debt that the directors wanted to set off was a liability of BCCI to the directors. That's why they wanted a set off, because otherwise they would have been relying on whatever dividend they would have got. So that is what the directors wanted to do. And of course, on a set off, it would count as 100%. If they could not set off, they get a dividend from BCCI, and they still have, the MS Fashions would still have to pay 100% of the debt it owed to BCCI. So on 431B to C, the directors signed a document which said that they were principal debtors, and it said, thus a common feature of all three cases appears to be that the director signed a document saying his liability to pay the company's debts was to be as a principal debtor. And then further down at E, just above E, on the other hand, I think it is a tenable view that such charges over deposits can be analysed as the creation of a liability on the part of the chargeor for the company's debt not exceeding the amount of the deposit, which can be set off against BCCI's liability to repay the deposit. It seems to me that the reference to the liability of the depositor as being that of a principal debtor should, as a matter of construction, be taken to have that effect. And then at 435 and A, letter H, in this passage, Lord Justice Hoffman explained why, if they had been guarantors, there wouldn't have been a set-off. He said if the relationship between BCCI and the directors was governed only by the standard form guarantees, I think that there would be no answer to the submission that the liability of the directors remains contingent. All the guarantees in the BCCI standard form require a demand in writing or any liability arising on the part of the guarantor. And then over the page at D2F, just above letter D, in my judgment, the principal debtor clauses have the effect of creating primary liability for the purposes of the rule, that's this rule in set-off, that the debt is not contingent upon demand. And then picking it up 2 lines further down, it is true that for some purposes the courts will look to the underlying reality of the suretyship relationship rather than the formal agreement that liability is to be as principal debtor. But this is only for the purpose of protecting the surety's equitable rights against the principal debtor and giving effect to such consequences as may affect the creditor, such as the surety's right to take over securities and the rule against double proof. Otherwise, there's no reason why creditor and surety not make whatever terms they choose. And then going forward to 439A to B, and this is Lord Justice Hoffman's conclusions and the declaration. Finally, Mr. Thomas said that although Rule 490 might result in a set-off and the between BCCI and the director, this did not amount to payment of the debt owed by the company, gave the director a complete or pro tanto defence. This, I think, ignores the fact that the director's set-off operates in respect of the same debt. That's what you need mutuality feelings, as that owed by the company. If, as I think it must be, the set-off is equivalent to payment by the director, then I think it must operate also to extinguish, to the same extent, the debt owed by the company. I will therefore declare that the indebtedness of each of the companies as at the date of the winding up, because this is by virtue of the operation of the set-off rule in 490, has been extinguished or reduced by the amount which on that date was standing to the credit of the directors on their respective deposit accounts. My Lords, the reason why Lord Justice Hoffman declared that the indebtedness had been extinguished is because there is a mandatory and automatic set-off where there are mutual debts, mutual dealings that occurs on the winding up. And that is what happened in this case, and that is what Lord Justice Hoffman.
Well, I understand that, but doesn't the reasoning go like this? The debt owed by the surety is not a contingent debt because it's a primary obligation. Therefore, set-off applies.
Yes, because you can have mutual dealings.
Set-off is equivalent to payment. Well, that's what he says. If, as I think it must be, the set-off is equivalent to payment, and set-off, being equivalent to payment by the director, extinguishes the debt, the company's debt pro tanto.
No, my Lord, you've inserted, with respect, you've inserted a layer of reasoning that is not there.
What have I inserted?
And what you've inserted is the set-off equals a payment, therefore it's extinguished the debt. The debt is automatically extinguished by Rule 490.
Why?
Because that's what the rule says.
Well, is it
You've
not?
taken account.
Is it not because, as Lord Justice Hoffman says, set-off is equivalent to payment?
No.
No. So that's
No, my
wrong.
Lord. Yeah. No, it's not wrong, my Lord. It's not. One can see why you would describe it as payment, but that's not the reason why it extinguishes the debt. A debt is extinguished when a set-off occurs under 490 automatically. You can't contract out of it, and it happens at the winding up.
Well, I understand that, but that's how set-off works. It's equivalent to payment. I mean, leave aside Rule 490. Just take common or garden equitable set-off outside insolvency. If you've got a set-off, it extinguishes or reduces the debt. That's how it works. You've got Hannack and Green. Mrs. Hannack sues Mr. Green for building works, and he has a cross-claim. And
well, my Lord, your Lordship may wish to insert that particular step, but it doesn't matter, because the crucial point in this is the reason why there was a set-off, whether it's because there's a payment or whether it's just the operating rule, is because they were primary obligors. And if they'd been guarantors, it wouldn't have been a set-off.
Well, I understand,
there wouldn't have been payment.
But we're dealing with an actual payment here, our case. Are we not?
Well, we're going to look at the facts in due course, but it's really important that your Lordship appreciates there is an absolutely core fundamental difference between payments by principals and payments by sureties, and this case is not a payment by a surety qua surety.
Right.
And that's really important.
Because they were primary obligors, which is upfront.
Yes, it is, my lady. And just to make it crystal clear, it is not because payment by a guarantor extinguished the debt. And that was not the ratio of the case. And that is important because we say that there are obiter dicta that are not binding on this court. And if they were, I suspect that the criticisms and doubts about the 3 lines of Lord Justice Dillon by the likes of Professor Good, Professor Gullifer and Andrews and Millett would never have been written. So, really important point. Well, we're not construing all these academics, but
No.
they are
Academics at perfect liberty say the Supreme Court gets things wrong. That's fine, though. Of course, they're entitled to their opinion. We're not.
But for my Lord, present purpose, if the debt from the directors had been by way of guarantee, it would have been a contingent debt and not set off.
That I understand.
Really important.
Yeah.
Then can I go on to 4468B?
Just before we get there, do we get any help? I haven't read it, I'm afraid, yet, from the report of the argument. After all, we have assumptions you see in Mark Hapgood appearing for the directors, one might think we might get some enlightenment from.
I'm going to look at.
If you're coming back to that.
Well, what happened was that there was an ex parte, an application, an ex parte interlocutory injunction in which all of those individuals appeared, went to Millet, went to the Court of Appeal, and then this is considered. Case. But I'll come on to that. Okay. And when we look at Lord Justice Dillon's statement, which I know that you have got, they take it out of context, because this was not an extinguishment because a guarantor had made a payment. And that's what I wanted your lordships to have understood. And what Lord Justice Dillon says there, that cannot be.
Sorry, where are you looking?
Cannot be the ratio. Sorry?
Where are you? Which page are you looking at?
Oh, well, it's the statement that has been looked at, which is 448.
448. Yes.
And just look at it above D. If there's a set-off between Mr. Amir and Mr. Ahmed and BCCI, that must automatically reduce or extinguish the indebtedness of the BCCI of the companies. A statutory set-off is not something which BCCI can, placing a suspense account, it operates to reduce or extinguish the liability of the guarantor. Now, it wasn't operating to reduce the liability of the guarantor qua guarantor. It was operating to reduce or extinguish the liability qua principal.
And you would say that that paragraph, which is at DE,
Yes.
is qualified by what's said above it at BC. Therefore, we have a situation in which, though the situation is tripartite rather than bipartite, and the case referred to earlier, all the rights are immediately enforceable, etc., there is a debt presently due from each of the companies to BCCI and equally due from Mr. Amir or Mr. Ahmad, as the case may be, as principal debtor.
Yes.
So you say that qualifies what is said below.
Absolutely. And what my learned friends are relying on is the use of the word guarantor by Lord Justice Dillon. And with the greatest respect, when Lord Justice Dillon used the word guarantor, he wasn't describing them qua guarantor.
Well, it's another way of putting it to say that one has to, as it were, to read into his penultimate sentence a guarantor, then sort of open brackets, qua principal debtor, close brackets, or something like that.
I don't know.
I mean, that would, as the lady says, would pick up the point which has been made very clearly at letter B above.
Yes. You want me to please. Yeah. May I then just turn to the other two bits of the history, which should be in additional bundle, Authorities Bundle 591. And I hope, my lords, that you have, and it may be in my little clip.
91 is in your little clip. Yeah.
Yeah.
That's Mr. Justice Millett, MS Fashions.
Yes. So this is the report of Mr. Justice Millett and then Lord Justices Wolf and Scott.
Yeah.
Mm-hmm.
And the first thing I wanted to show to your lordships is the dates of the two decisions.
Yes.
This all happened on the same day, because what had happened was that BCCI, in liquidation, had appointed receivers over MS Fashions based upon the debt due from MS Fashions to BCCI, and the directors ran along and sought an injunction restraining the receivers from acting. Mm-hmm. And so this all happened very quickly. If you just go to 281, you can see those who appeared and were instructed before Mr. Justice Millett, and the same you can see on page 284. And I just wanted to pick up on 284, just above letter E, where Lord Justice Scott says the argument for Mr. Justice Millett and before us raises a short point of law concerning the effect of Rule 490 of the insolvency rules. And then, if I can go forward, what page? Sorry, what page?
He makes the principal debtor point.
Yes. Sorry, I'm very grateful to my learned junior who was trying to prompt me to point that out to your lordships, but you've got the point.
Sorry, where is it we find that?
That is on 284 at the bottom.
What G?
Just to render.
284H over to
Yes,
285.
you can see
Yep,
the
you.
principal debtor will on demand and so on.
Yep, yep.
And then on 287, if I can pick it up at H, where he says, picking up the second sentence, it's correct that the release of a surety does not discharge a principal debtor. Nothing but payment does this. I would accept also that BCCI can, if it wishes, release the guarantee and still enforce its security against the companies. That does not seem to me to be the point raised by the facts of the present case. It's plain enough that payment by the surety, whether in whole or in part, the case may be, not only releases the surety but also discharges or reduces, the case may be, the liability to the creditor of the principal debtor. The set-off effect of 490 in reducing Mr. Sarwar's liability to BCCI corresponds to the payment of the corresponding amount, which of course is the point. I take that. And then over the page, just above letter D, where he says, I think this is a case, and I think that's the passage, my Lord, that my Lord Justice Lewison was referring to yesterday. But I think it's important that we then look at 288 just above D. He says, I think this is a case in which leave should be granted to Mr. Sarwar and the company to seek a declaration. The amount of the debt.
Sorry, where are you? 280?
288.
88?
Yeah.
Sorry, yeah.
No, my fault.
Oh, yes, I see.
I think it's a case in which, just above D,
Yeah.
in which leave should be granted. So this is a leave application. It should be granted the company to seek a declaration. The amount of the debt they owe has been reduced by the operation of 490 to the extent of the sum standing to credit for Mr. Sarwar in his deposit account with BCCI at the date the BCCI went into liquidation. If it had been left to me now to rule as a matter of law on the matter, what I have already said indicates the conclusion to which I would have come. But this is only an application for leave. It is not the full hearing of the issue, although it was necessary for us to form a view on the issue having regard to the manner in which it was dealt with below by Mr. Justice Millett, who refused to intervene. So your Lordship should note no cases were cited to the courts according to the report. There are no cases cited. No cases cited. If you look at 284, you can see there's no reference to any cases having been cited. You can see that it all happened in a tearing rush. You can see Lord Justice Scott's expression that this is only a leave application. So one cannot fairly put particular weight on the way in which Lord Justice Scott described the issue.
Do you want to say anything about Lord Justice Wolfe at 289 between G and the quotation?
Between?
Or H. Once there's been set off, the company's been paid. That means that not only is the guarantor or joint principal discharged to the extent of the set off, but so also is any other debtor who is liable in relation to the same sum.
Well, I think, my Lord, you have the majority behind the proposition that set off constitutes a payment. It's, I don't want to push the point. I'd always thought of it as the automatic operation of Rule 490, but it doesn't matter, and that's one reason why I really don't want to push it. Just to make a few points, just to pull MS Fashions together. MS Fashions concerned principal debtors. Your Lordships should note that the Court of Appeal, of course, was not shown re-sas, although given that the extinguishment of the debt was because of Rule 490, that's not as big an issue as it might have been. And it was because they were principal obligors rather than guarantors as well. Of course, there are comments in the textbooks that I should just show you. Appeal Authorities Bundle 472. Again, I'm going back to Good and Gullifer and back to 414. And the point I wanted to pick up was just after, in the middle of the paragraph that we have looked at, it's just after the quote that we were looking at from Lord Justice Dillon in MS Fashions. It then says, however, neither re-sas nor Ulster Lamb were cited to the Court of Appeal in that case.
Ulster Bank was, of course, cited to Lord Justice Hoffman.
Yes, it was. No, my lord, absolutely. Your lordship's absolutely right. Absolutely. And the other point was in 71 in the law of guarantees. Yeah, sorry, this is Andrews and Millett. And I just wanted to go to 2377. And it's just footnote 53 where Andrews and Millett make the same point. Just, and they say at the end that this remark, it is respectfully submitted, should be treated with some caution. And our respectful submission is yes, but I think that my lord, your lords, now and your lady, you now understand why that statement was made and what the context was.
I'm sorry, which footnote was that?
Oh, footnote 53, my lord.
53, thank you.
53.
Yes.
And the last is again, it's in the little clip. If it assists your lordship, in the clip you will find copies of an explanation of this case from the modern contract of guarantee.
Yeah.
And they explain the case in its proper insolvency set-off context. And it may assist your lordships when you come to consider the case for the purposes of your lordship's judgment. What does that mean?
This is 11.101 and following, is it?
Yes.
That what you're referring to?
Yes. 11.101 and following. Yeah. Now, the next authority is Stotter and Equity Court, which is an authorities bundle 26491. But looking at the time, I'm going to just give you a couple of points, if I may.
Yeah. Tab number again?
It is authorities bundle 2126.
Sorry, authorities bundle
26.
Yeah, we've got that one, and we've got Mr. Justice McMurdo as well, haven't we?
This is this one's this is Fisher.
Yeah, this is New
The
Zealand.
High Court of Auckland,
And then we've got McMurdo back in Australia.
yeah. But what I wanted to do was can I just as your lordships know, the case held that a creditor's proof in the liquidation had to be reduced by the amount received from the surety before the onset of liquidation, and it relies on McKinnon, Rowlett, and Lord Justice Dillon and Milverton, many of those points that your lordship has seen, without properly analysing those points. If you have, and I'm sorry to flip about, but I just want to show you textbook material on this.
Can I just ask you a question before we go there?
Yeah, of course.
You have been submitting that, properly understood, both MS Fashions and Milverton are explicable on the basis that the surety was in fact a principal debtor.
Yes.
And on that hypothesis, I think you accept that a part payment does discharge the debt pro tanto.
Yes.
Again, on that hypothesis that the debt is discharged wholly, pro tanto, what is the impact on the right to prove, if any?
Well, the debt, you can only prove for the balance left after the payment.
So if the debt is discharged pro tanto, then the creditor can only prove for the balance. Is that right?
Yes.
Right.
Yes. Yes, because you've got two individuals who were liable to pay the debt, and one's paid it.
Yeah.
And the creditor can only claim up to 100% from his principal debtors.
Creditor can claim.
Well, they can only claim if you've got two principal debtors.
Yes. So if he's got two principal debtors and one pays, they owe 100 between them. One pays 50.
Yeah.
The creditor can only prove for the other 50.
There's only 50 left.
Yeah. And if he only gets a penny in the pound, that's just tough.
Yeah. And if he's got a guarantee, then the guarantor might have to pay the other 49. And if the guarantor pays 50, then the guarantor can step into his shoes, put in the proof, and he gets the 1p in the pound. Right. Tab 75 at 2425. Bill Authority Bundle 4, tab 75, 2425. And it's 2425 at tab 75.
Oh.
And it's 1081. And it refers to Ms. Justice Fisher and then says this: with respect, the reason why the creditor stands to receive more than the other unsecured creditors in the liquidation is because that is the basis on which the financial accommodation was provided to the principal debtor and the basis on which the guarantee was taken. In any event, the creditor does not receive a proportionally higher dividend on its debt. It is just that the principal debt is not reduced by the pre-liquidation payment, so that the amount on which the creditor's dividend is calculated is the gross amount of the debt. This is a consequence of the creditor's right of appropriation. In any event, the creditor is not entitled to receive more than 100% of the pound, and if it does so, it will hold the surplus on trust for the paying surety. So again, I think your lordships are seeing the structure of how this works. And as far as Stotter is concerned, if you could just go to 71, tab 71, page 2371. And it's it's on 2371. It's the last few lines of 13.010, where they say, there are, however, competing policy considerations which offer reasons to be cautious about accepting Ms. Justice Fisher's view too warmly. Furthermore, it's hard to see why there should be such a fundamental distinction between payments made by the surety prior to the insolvency and those made after insolvency as supervened. There's also a powerful case for saying that the guarantee is for the whole of the debt, and the creditor is entitled to treat the surety as having not performed his obligation until he has seen to it that the entire debt has been paid. And then in tab 72, back to good, on 2382 again, and this is a different part of the page, I'm pleased to say. After the break, Professor Good moves on to Miss Justice Fisher, and then 5 lines up from the end. The policy argument against the resulting stutter is also strong, since it creates a distinction between payments made by the surety before liquidation, for which the creditor has to give credit, and those made after, which he does not. Fisher deals with this argument on the basis it's no more anomalous than other situations. For example, where the surety is insolvent and the debtor has made a payment, however, pointed out above. Payments made by the person primarily liable do not fall within the rule in SAS. It is submitted, therefore, the position in English law remains that partial payments by a surety do not reduce the amount for which the creditor can prove. By partial payments is meant payments of less than the total indebtedness to which the guarantee relates. If the creditor has misguidedly taken a guarantee covering only part of the debt, opposed to a guaranteed full indebtedness with a limit of liability, then on paying that part, the surety becomes entitled to lodge a proof himself in respect of the part so paid. Again, we agree. Yeah, and my lords, just in relation to the public trustee of Queensland, our submission, which is Miss Justice McMurdo, our submission on that is this is all of a piece.
Yeah.
And so rounding it up, and I'm sorry, I felt I needed to deal with
No, you're quite right.
There is no inconsistency between the position outside and inside an insolvency. And at step 1 of the analysis, the position outside of a winding up is that it is possible to sue for the full amount, even if there's been a payment by a surety. If the surety pays 100% of its liability, the right of subrogation means they step into the creditor's shoes to the extent of their liability. And that is what the rules are. Can I then move on to the impact of insolvency? And the rule inside an insolvency is the same as the rule outside an insolvency. And before we do so, we'll flag up one point on the facts in this case, which is that no payments were actually made on the LDHI guarantee pre-insolvency. They were all made post-insolvency, just so that your lordships are aware of that. The reference is CB 119. Then if I can just go back to re-SAS, because I now want to deal with the insolvency part of the case. So that's back in Authorities Bundle 1 at 9.
SAS, did you say?
Well, yes.
Tab 1.
No,
Tab 1.
Yeah.
tab 1. I'm sorry. Page 9, tab 1. Your lordships have seen the head note. Your lordships know the facts. I just want to go to internal page 15.
Yeah.
And your lordships can see the marked passage. Surety has a right to being paid. So your lordships, I think, have seen that. And the court held, as your lordships know, the creditor may prove for the full amount of their claim. That is the same as the position pre-insolvency, notwithstanding the payments made in respect of the claim by a guarantor, unless and until it's repaid in full. And then I'll just give you the references. And sorry, I should do this properly. Authorities Bundle 4 at tab 71 again. On page 2369. And I wanted to pick it up 5 lines in. Do your lordship see the words in the middle of the page, the basis for the rule?
No, I'm sorry, I'm on 2369.
2369, 13007.
Yes.
I'm sorry. And then
the basis for the rule in the middle.
The basis of the rule.
Yes.
The basis for the rule is that the surety is undertaken to be responsible for the full sum guaranteed, including whatever may remain due to the creditor after receipt of dividends in the principal's insolvency, and cannot prove, or more correctly receive a dividend in competition with the creditor for a right of indemnity. And then in ROLAT, which is at tab 69, and this is 2357. In 11/002, and just above the break at the bottom, 4 lines up, the words "the better view."
Yes. So they don't like stotter.
They don't like it. So that brings us to the impact of release, which is step 3 of the analysis. And Deutsche Bank's point boils down to one argument, which runs as follows. LBHI has released its right of indemnity altogether. That means the rule against double proof is not engaged. There are no competing interests between the senior creditor and the junior creditor, the surety. That means resas cannot apply. If it did apply, there's a risk of overcompensation of the creditor, and this would be contrary to the pari passu principle, and accordingly, the general principle outside insolvency should apply. Now, before we get into this, because I think your lordships can already see the answers to those various points, but before we get into this, one complaint my learned friend made was that the learned judge had not dealt with the point. And in fairness to the judge, I think your lordships should be aware that this point took on a new and much increased significance in a note produced by Deutsche Bank a week after the hearing had finished. So, in fairness, sorry? And that's at SB2 tab 18. Now, on the point of substance, the argument is based on 2 major flaws. First, there will be no risk of overcompensation if the rule in resas is applied. The estate of the debtor is still liable to 100%. That has not changed. The surety is liable up to the extent of their guarantee, and of course, if the creditor recovered more than other creditors, it is because they took a form of security. But LBHI is not entitled to take more than 100 pence in the pound, which I'll come back to, and it makes no sense to disapply the rule in resas. Actually, I would put it more widely than the rule in resas. It is just the rule in the context of guarantees outside and inside of an insolvency. So the first flaw is that they do not recognise that it is the surety's claim to be subrogated to the creditor's claim that has been released. It is that claim, the secondary liability, that is what has been released. The competition avoided by the rules that we have.
What has been released?
I
thought the claim to indemnity from the principal debtor had been released.
Yes, against the surety. What? Yeah, right, sorry. Yes. Sorry, yes, I've been on my feet for too long, I think. Yes.
Under normal principles, if the surety pays what is guaranteed when the principal debtor has failed to pay, he, the surety, is entitled to an indemnity from the principal debtor.
Yes. That has been released.
That is what's been released.
Yeah, I'm so sorry. Yes. But what you can't have is any competition between the surety and the creditor. And the release by the surety ensures there will be no competition in any event. The creditor can, or it has been able to prove for the whole debt, and there is no reason to interfere with the ordinary operation of the rules.
Well, suppose that the debt is 100, the surety pays 50, the creditor proves for 100 and recovers a dividend of 60p in the pound. So he now has in his hands 110. What is the obligation he has to account for that
I'll show
10
you.
to anybody? Surety, who no longer has a claim because he's released it.
Under the settlement agreement, he has to pay it back.
Ah,
I'm going to show you that.
right.
And I'm sorry, I was standing with my mouth agape. I will show you that because as part of this release, you have got the obligation to repay if they did recover more
Right.
than 100%. But I do need to show you that. I'm aware of it. So if I can just, first of all, just look at the position of the estate. The creditors are faced with a proof for a total of 100% of the debt. There's no risk of compensation, overcompensation of LBHI out of the estate. And there's no infringement of the pari passu principle. There is that. But then on the facts, and I need to show you that core bundle 5, tab 57. This is the settlement agreement, which, as your lordships will have picked up from the judgment, is governed by New York law. Fortunately,
That's why it's so difficult to understand.
Well, my lords, I, amongst others, had the pleasure of cross-examining experts of
Yes,
New York
I
law,
saw.
so no comment. Right. But anyway, 204.
Clause.
Clause 204, which is on page 1315. Sorry, did I not give you the page?
Yes.
What it provides, I'll just work through it. On the effective date, each applicable UK affiliate will have allowed claims against the applicable debtor in the applicable classes and in the aggregate amounts. And then, notwithstanding anything to the contrary in the plan or this agreement with respect to each UK affiliate claim for which the applicable class is set forth, each applicable UK affiliate agrees that if at any time such UK affiliate receives distributions on account of a UK affiliate claim, which is what we're talking about, that combined with any distributions received by a UK affiliate on account of the relevant primary claim exceed the amount of the primary claim, such UK affiliate shall remit from time to time any such excess distributions to LBHI, but that's not in our capacity. Within 7 business days of receipt thereof, and such remitted excess distributions shall not be subject to reduction, avoidance, recharacterisation, reconsideration, recovery, subordinated merger, and so on and so forth. But the short point is any excess received over the primary claim then has to be remitted back. Now, so that's on that side. The claims against the state are the same. The creditor can't be overcompensated. And on the other side, if the rule wasn't applied, there would be an unfair windfall to PLC as the debtor because of LBHI's reduced proof, because the estate would not be faced with a proof for 100% of the claim. So there would be a windfall, but the other way.
To the estate.
To the estate. There's absolutely no reason not to permit a proof for 100% of the claim.
Yeah.
The other fundamental problem with my learned friend's propositions is that the rule outside and inside insolvency is the same. And even if we were wrong about the application of RESAS, the default position is the same anyway, as I hope I have demonstrated to your lordships.
Well, I think you both agree that the rule is the same inside and outside. You just disagree what the rule is.
I think they say it's different, but for my purposes, I've shown your lordship what the rule is, and we say it's the same throughout, and we say that RESAS is the application of the rule in an insolvency situation.
Yeah.
Which brings me to clause 7F, which was the point advanced by my learned friend Mr. Fisher, and I will be thankfully very short. My learned friend described the submission as an observation, and for your lordship's notes, we've dealt with this in paragraphs 107 to 111 skeleton. We've made a procedural point. I don't think your lordships are going to be too troubled by it in the context of an observation. And we have we've made a substantive point. And can I just make a few short points? Clause 7F says, and your lordships have seen it, that the lender will not, without prior consent of the FSA, take or enforce any security, guarantee, or indemnity, and so on. And upon obtaining or enforcing a security, guarantee, or indemnity, undertaking to hold the same or any proceeds on trust for the borrower. We understood from the skeleton that my learned friends were making a point about set-off, which we explained was flawed because you're dealing with a trust claim as against a straight debt claim. But my learned friend orally made a point about the underlying economics of the arrangement. Given that it's A, hypothetical, B, new, and C, just an observation, I would respectfully leave it there.
All right.
My lords, with huge apologies again for taking
No problem.
Are there any, do your lordships have any other questions?
Okay. Thank you very much.
Thank you very much, my lords.
Right. So who's next? Miss Hilliard.
Yes, I have a right of reply, my lord. I have 7 points, short points in reply. First, a response to Mr. Phillips' suggestion that our assertion, actually, that our argument is illusory, or that we are trying to argue that a pari passu solution becomes a senior ranking for D. This, as we understand it, is a variation of the point that my lord, you made, you put to me yesterday about there being a now you see it, now you don't quality about our argument. Our answer to this is as follows. Firstly, it has to be firmly borne and clearly borne in mind that the effect of the different definitions is that first, C is subordinated to everything other than more junior excluded liabilities. If another instrument, in this case D, is not more junior, it must be senior. Secondly, D is subordinated to everything other than more junior excluded liabilities and pari passu subordinated liabilities. So it follows that, thirdly, 3, the class of things that C is subordinated to is wider than the class of things that D is subordinated to. Or, putting it another way, the class of senior liabilities from C's perspective is wider than the class of senior liabilities from D's perspective. Next, the relevant conclusion that one takes from a construction of claim D is that it does not express itself to be junior to claim C. The fact that claim D, from its perspective, would see claim C as pari passu is just a step along the road to that conclusion, but it's not the conclusion. So if you view the conclusion of the interpretation exercise of claim D as being that claim C actually ranks pari passu, which is what Mr. Phillips says our argument was, then now you see it, now you don't objection, does, we accept, have some force, because we know that claim C does not end up ranking pari passu. But that's not the right conclusion to draw from our interpretation of claim D, our construction of claim D. The construction of the subordination clauses in claim D is only to identify, and nothing more, which other debts claim D ranks behind. Subject to that, whether or not other debts ultimately rank pari passu or alongside claim D is, and I think we explained probably too many times yesterday, but is not within claim D's gift. It depends on what the terms of the other instrument say about itself. And in the event of inconsistency between the two instruments, the legal methods of dealing with that inconsistency. So the mischaracterization of our argument by Mr. Phillips is when he says that we say that D and C must rank pari passu. We in fact say, from D's perspective, it would treat C as ranking pari passu. We stressed yesterday the outcome of the subordination exercise from claim D's perspective is only that it's not subordinated to claim C. The outcome of the subordination exercise from claim C's perspective is that it is subordinated to claim D. And both those two statements will be true if claim D ranks ahead of claim C. And there's no now you see it, now you don't about that. That's the outcome. So when my Lord Justice Lewison suggested to Mr. Phillips yesterday that his argument was that our argument was self-contradictory because it involved a pari passu outcome leading to a D ranking senior outcome, Mr. Phillips agreed with that, agreed that that's what his argument was, but as I've explained, that's wrong. That's not our argument, because we do not say that there is a pari passu ranking, there is an actual pari passu ranking, only that from claim D's perspective, it would treat claim C as pari passu. And I have to say, in any event, Mr. Phillips' own position also suffers from the same problem, because his position is that he says that because claim C views claim D as senior, claim C ends up ranking pari passu with claim D, but senior. On any view, there's going to be something of an inconsistency in the way that claim C and claim D view each other. But we say that the outcome of that is an entirely and always consistent one in terms of subordination. C is expressed to be subordinated to D, but not vice versa. So that's the first point. Second, and relatedly, Mr. Phillips' argument that there is a circularity in the simple contractual mechanism which should be addressed by a pari passu outcome creates, we say, a yet further problem when one comes to apply the solvency conditions in the PLC subdebts. And that's effectively Deutsche Bank's ground 3A argument. But Mr. Phillips was wrong to suggest that we, GP1, accepted without more that the solvency condition did not affect our analysis. It only doesn't affect the analysis if our construction is right. If Mr. Phillips' preferred outcome is correct, then it does create a problem with the solvency condition. And Mr. Phillips didn't have any solution for resolving it. And we can deal with this very quickly if we just want to look at claim C in the sum of 4.5 billion. You probably remember the terms of the claim C subdebt. But if you want to turn it up, it's volume 3, tab 43, page 757. Relevantly, clause 5.1 provides that the rights of LBHI in respect of the subordinated liabilities under claim C itself, are subordinated to the senior liabilities, all liabilities except subordinated liabilities and excluded liabilities, and accordingly, so it follows, payment of any amount of the subordinated liabilities, i.e. liabilities under claim C itself, is conditional upon PLC being solvent at the time of and immediately after payment. And the application of clause 5.2 means that PLC will only be solvent if it's able to pay all other liabilities other than the subordinated liabilities under claim C itself in full, disregarding for our purposes, the excluded liabilities. Now, if one accepts Mr. Phillips' proposition and we proceed upon the basis that the statement of subordination to senior liabilities creates a circularity that reverts to a pari passu ranking by some form of default legal rule, then that solution presents a further problem under that insolvency condition in claim C. Because if claim D ranks pari passu with claim C under the subdebts, then claim C cannot be paid on the terms of the instrument because the solvency condition will not be met. And the reason for this is, of course, is because the solvency condition in claim C can only be met by disregarding excluded liabilities and liabilities under claim C itself, the subordinated liabilities under the terms of claim C. So a pari passu competing debt at senior level, which is where Mr. Phillips would have claim D rank, is not a subordinated liability under claim C or an excluded liability. On that basis, payment of claim C cannot be paid unless claim D could be paid first before the payment of claim C. So if Mr. Phillips is right, a pari passu ranking with C will necessitate yet a further exercise in impasse breaking in order to explain and justify why a debt that ranks pari passu cannot be paid pari passu. Now, Mr. Phillips seems to suggest that this could be solved by having claim C treat claim D as being within the definition of subordinated liability in claim C. But that requires the implication of entirely new words in claim C, which are not present at all in claim C, but are present in claim D. And we say that this analysis serves to reinforce the sense of the construction that we've advanced. It's the other side of the same coin. Once it's recognised that claim D, properly construed, does not subordinate itself to claim C, an outcome which replaces one perceived impasse with another perceived impasse simply doesn't arise. And so our construction is the only construction which properly allows accordingly to mean in consequence. It follows that in both agreements.
I haven't quite got my head around this one. We're looking at clause 5.1.
Yes.
So the rights of the lender are subordinated to the senior liabilities, and accordingly payment of any amount of the subordinated liabilities is conditional upon, and then we go to which...
Sorry, over the page to 758, it says 1b, the borrower being solvent at the time, because the first bit is outside of an insolvency.
Yeah.
So the borrower being solvent at the time of and immediately after the payment. And then 5 subparagraph 2, for the purposes of subparagraph 1b above, the borrower shall be solvent if it's able to pay its liabilities other than the subordinated liabilities in full, disregarding the excluded liabilities.
Right. So the point is that if claim D is not subordinated, it's pari passu, then it's got to be paid.
Yes, yes. And so what you would have to do is you'd have to create another sort of impasse breaking mechanism to allow the debts to be paid.
Right.
So what I was saying is if we accept Mr. Phillips' proposition and we proceed upon the basis that the statement of subordination to senior liabilities creates a circularity that reverts to a pari passu ranking by some form of default legal rule, then that solution, as I say, presents this further problem under the solvency condition in claim C, because it means that if claim D ranks pari passu, then claim C can't be paid on the terms of the instrument because the solvency condition will not be met. And I think Mr. Phillips' suggestion was that this problem could be solved by having claim C treat claim D as within the definition of subordinated liability in claim C. But as I say, that would require the implication of just more new words in claim C, which are not present in claim C but are present in claim D. And that's why we say ours is the only construction which really works, because once it's recognised that claim D, properly construed, doesn't subordinate itself to claim C, an outcome which replaces one impasse with another just simply doesn't arise. The third point, it was unclear at the end of Mr. Phillips' submissions the extent to which he continued to rely on the default rule under Rule 1412. But to the extent reliance remained, I think it was in echoing the comments made yesterday by my Lord Justice Henderson as to whether D's perception of C as a pari passu debt arises as a matter of construction or because construction runs out and it's necessary to have recourse to some other legal principle. And we say there's no need, and that's really the whole point of our submission, is that there is no need to get to a default rule. It's quite an attract, and I think that we were there on a sort of earlier iteration of our arguments. We thought, okay, we'll use the default rule, but actually, when you look at these instruments, you don't need to. You don't run out of construction opportunities because the construction works. An approach which requires reliance on a default rule, such as that suggested by my Lord Justice Henderson, requires this two-stage process. First of all, it requires a construction of claim D that treats C as a senior liability, which was the judge's conclusion and the one that Mr. Phillips invites you to endorse. And second, it needs a recognition that can't work, because in the event that claim D ranking, in that event, sorry, claim D ranking with claim C would create a circularity, and that therefore the only solution is to treat the debts as pari passu, either under the default rule or on the policy ground we suggested, or via some other legal mechanism. And what we say is it would be peculiar to require this hypothetical two-stage process where D on its own terms can land on a workable solution in one stage as a matter of construction. I mean, one doesn't have to go through all these legal mechanisms, because we can do it by construing the documents. Or to make the same point another way, it would be an absurd construction of claim D, which led to a circularity problem, when there was available a construction that didn't. I mean, generally the law seeks to avoid absurd solutions, particularly when there is a perfectly principled and logical alternative available. And to go back to our second point in this context, it's that by solving the problem as a matter of construction, that you avoid giving rise to the further problem that the solvency condition in claim C would still not be met. That problem is only avoided if one reaches the conclusion that D, on a proper construction, does not subordinate itself to C. And if one reaches the conclusion that D, on a proper construction, does subordinate itself to C, so the opposite, then one is driven to solve the circularity by some form of legal default. You just create a further problem in that claim C's solvency condition can't be met, and so some further remedy is required. The fourth point is that Mr. Phillips submitted that no reason has ever been identified for C and D to rank other than pari passu. Our answer to that is no reason has ever been identified why C and D should not rank other than pari passu. I mean, if Mr. Beltrami is right, and we say he is on his construction of amended B ranks below A. Amended B ranks with A other than pari passu. B ranks below A. Secondly, our response is no one ever appears to have thought about the relative ranking of subordinated debt, and it's not suggested that it was. And if no reason has ever been identified for C and D to rank other than pari passu, that fact, we say, goes absolutely nowhere, and certainly nowhere near to leading to a pari passu outcome. It just means that one should not be surprised if the consequences of the language used when it comes to ranking do not have a readily discernible rationale.
I thought Mr. Laney did suggest a reason which wasn't entirely tied up with the dividend stopper argument, which is that the issue under Claim D was designed to bring in outside money.
Yes, well, that I'm happy to support Mr. Laney. No, I mean, when I introduced the case, I obviously did explain that the ECAP investors provided. I mean, that the structure was all designed to attract third-party investor money, to funnel it up to the limited partnerships, and then through to purchase the notes, and that structure was, it wasn't a happenstance. It was purposely put together with the limited partnership having agreed to purchase the notes even before the prospectus went out. So yes, that would be a reason to, well, it would be more of a reason to put D above C than C above D, bearing in mind that the C debts are totally internal to the Lehman Group. And as I say, I'm happy to sort of row myself towards Mr. Laney on that. I do say that our construction argument, though, if you like, Mr. Laney's argument supports our construction argument. So in other words, if our construction argument didn't work on its own, the point that Mr. Laney has made wouldn't be enough. But taken together, it does give our construction argument more force, I think.
Yeah, right.
Fifth, Mr. Phillips placed great emphasis on the specific sanction of FSA in relation to the departure from the standard form 10.6 when putting in place the PLC subnotes. And this again, we say, goes nowhere. It seems to be an argument that the draftsperson or FSA subjectively intended the form of the notes to be the same as the debts. There's no rectification claim, and even if that subjective intention were admissible, and I have to say I struggled to see that it is evidence of any intention, but if it was admissible, it's of no use as an aid of construction given the judge's finding. That
But it's not relied on.
No, it's not relied
on as subjective intention. What is being said is, here is a departure from the standard form. That can only happen legally, in regulatory terms, if the FSA has sanctioned the departure. The FSA's sanction is public document, and therefore available to anybody who's buying into these notes. The FSA's sanction says, well, you can depart, but there must be no less subordination than the standard form, i.e. than claim C. If you're right, then there is less subordination than claim C. Therefore, you should interpret claim D so as to conform with the regulatory framework. That's the way the argument goes.
Yes, I've momentarily lost my reference, but the judge actually did deal with this in his judgment, and he said, he said, and we'll find the reference. He did actually say, look, if in relation, interestingly enough, to the subdebts, because the subdebts didn't comply all fours with Form 10.6, and and what he said, this is at paragraph 326. It starts at paragraph 322, regulatory irregularity, page 454, tab 22 of Court Bundle 2. This is obviously dealing with the PLC subdebt agreements, are very similar to the LBHI2 subdebt agreements, which comprise Claim A. And he goes on at paragraph 323. On the other hand, these differences, he refers to differences, are sufficient to render the PLC subdebt agreements non-standard when considered in relation to the form followed by the LBHI2 subdebt agreements. That form, it will be recalled, was laid down in IPRU in 10, so forth. The reason for the failure to follow in all respects the standard form was explored in cross-examination of Miss Hutchison by Miss Hilliard QC. Miss Hutchison, entirely unsurprisingly, could give no direct evidence as to why this might be the case. She did, however, seek to explain why this might be the case, and her first explanation was that an error had been made. Her second was that this might have been a case where the standard forms did not have to be used. Both explanations are possible. The fact is that someone in Lehman Group took the form and then varied it or caused it to be varied in a manner beyond that permitted if the regulatory capital regime applied, and this was intended to be regulatory capital. As I've noticed, the standard form envisaged only that the section B variable terms could and would be altered, and these changes went beyond that. And whilst it's possible that a standard form for regulated capital was used, albeit with some changes, in a case where the standard form was not in fact required, it seems to be more likely that changes were made in circumstances where the standard form should have been adhered to, but was not. I raise this point so that I can dismiss it for the purposes of this judgment, even assuming the form of the PLC subdebt agreements. Remember, that's the PLC subdebts, not the notes. was deficient. The most that this could have done was rendered what the Lehman Group intended as regulatory capital, not regulatory capital. Obviously, that would or might be serious in the regulatory context, but any such deficiency would sound only in the regulatory context and would not otherwise affect the obligations arising under the PLC sub-agreements. In short, the rules regarding regulatory capital and their potential breach have no bearing on the questions of subordination that I must address.
Is that right, then?
Yes.
I mean,
Because
if a
the reason why...
if a contract is made intending to give effect to a regulatory scheme, or a legal scheme for that matter, and it could be interpreted so as to conform with the scheme, and it could be interpreted so as not to conform with the scheme, wouldn't a court interpret it, if possible, so as to conform?
Well, first of all, the actual FSA letter, I think, on any view, is somewhat unhelpful and ambiguous. It's certainly not dealing...
Never mind the particular facts.
Yeah.
The judge says regulatory consequences have no bearing on the question of subordination, i.e. they cannot affect my interpretation of the agreement. And I'm questioning that.
My Lord, yes, I think I think they can't have any bearing, because the agreement is not with the FSA. The agreement is with LP1 and PLC. I mean, the FSA might be saying, you've got to have these terms in your agreement. But if the agreement, if the notes that are issued to LP1 don't have those provisions, the idea that LP1 would not be entitled to enforce the provisions of the notes because of something that a regulatory authority said would be somewhat surprising.
So your submission is that regulatory compliance has no bearing on interpretation?
Well, no, my Lord, because I think regulatory compliance is coming quite close to, bearing in mind that it's the FSA's, but for this argument, is saying this is what we require, is actually coming close to the subjective intention of a party that isn't even a party to the agreement. I mean, I think really the way to put it is that this is the tail wagging the dog. If the wording did not achieve, assuming that was what the FSA wanted, it did not achieve that which FSA and Allen and Overy meant it to, then it doesn't mean that the wording does not mean what it means.
No, I understand that.
It might mean that the FSA rules were breached.
The parties' rights and obligations are in the end governed by the contract.
Yes.
All I'm questioning is the judge's statement that the regulatory background is irrelevant.
Well, I do not see the relevance of the regulatory background to the enforcement of the obligations.
Right.
And just to make my point good in relation to the waiver, which is what Mr. Phillips was relying on. I mean, the FSA waiver letter acknowledges the possibility that the agreement might not, in all fours, comply with what the FSA wanted to comply with, because the FSA waiver letter requires the FSA to be notified if anyone spots a problem with the terms of the waiver. So the FSA isn't saying, look, if these terms don't comply with what we require as a matter of regulation, that we won't regard them as enforceable, or will take some action to stop these provisions being enforced. The most that the letter goes to is requiring someone who picks up a problem to notify the FSA. And what I say in terms of the waiver letter is, it's looking at what the FSA was saying, it's very unlikely that when the FSA used those words, would have been thinking that the ranking that we're pushing for created any difficulties from a regulatory perspective. Because whilst the wording, we say ranks the subnotes above the subdebts, it ranks behind all the other already paid unsubordinated liabilities. And that, I say, is all that the FSA cared about. Why should they have had any concern about where subordinated liabilities?
Yeah. Well, you've got the judge's finding to
themselves?
that effect.
Hmm?
You've got the judge's finding to
Yes.
that effect.
I mean, there's absolutely no room in the construction of the subnotes and the debt for a gap in which some unsubordinated debt accidentally gets sandwiched between claim D
Yeah.
above and claim
So
C below.
your point is that when the waiver says that there must be no less subordination than the standard form, what it means is no less subordination vis-à-vis unsubordinated debt.
Exactly. And that must follow, my lord, because, as I say, there is absolutely not and why should the FSA be worried about where subordinated liabilities rank between themselves? That wasn't their concern.
Yeah, right.
So, subordination isn't to a fixed level, it's always relative. And whilst Mr. Phillips characterises the outcome as claim D not subordinating itself to the same level as claim C, it's equally consistent to view the result as being claim D subordinating itself to the same level as C, but then C expressly, which it does, expressly relegating itself down a further rung. I mean, the instruments are welded together at what might be described as a Form 10-6 bracket, but it does not mean that everything in that bracket needs to rank pari passu. Yeah. And indeed, the forms themselves, the subdebt forms, don't permit a pari passu ranking. So the FSA can't be taken to have intended all Form 10C debt to rank pari passu because their instruments don't actually permit that. In short, and to the extent that it's relevant at all, what FSA and I say mean by the same level of subordination is, as I've said, it's subordination, but subordination to unsubordinated debt.
Yeah, you've said that.
And finally, on this topic for completeness, sorry, right, okay. So I'm getting there. Oh yes, I will finish today.
Well, you've got two more points to go.
Yes, no, they're not very long. They're short.
Still Mr. Tullaney to come, so I think we'll probably call it a day there.
Very well.
And start again tomorrow. Mr. Tullaney, I think you've got 45 minutes, is that right? Right, all right, 10:30 tomorrow.